Hi, everybody. Thank you so much for joining us today, and welcome all to the first public discussion of the Genocide Scholars Expert Group. This expert group was established in October in response to the growing discourse surrounding the nature of Israeli violence in Gaza and the broader structural violence against the Palestinian people since 1948. The group is comprised of scholars with wide-ranging expertise in genocide, including scholars of Holocaust studies, the genocide of the Herero and Namakwa people, settler colonialism and colonial genocides, the Bosnian genocide, the Genocide Convention, ecocide, and more. The group can be followed on X at Genocide Experts. Today's discussion is the first of monthly public discussions the expert group plans on holding in collaboration with Law for Palestine. The conversation today, titled Genocide, International Law, and Beyond, will focus on genocide as an international legal doctrine, but also genocide as a structural and socio-legal process and concept. It will balance the urgency to deploy the descriptive legal term of art with critiques of the legal framework and introduce socio-legal conceptions of genocide, its meaning, and its history. The conversation will apply these important questions to the urgent situation in Palestine today and draw from related context. And I'd now like to pass it to Arnesa for introductions.
Thank you all for being here with us. My name is Arnesa Kustura. I am an expert in the Bosnian genocide. I'm also myself a Bosnian genocide survivor. My area has been heavily focused, my area of research has been heavily focused on the differences between the sociological framework of genocide and the international law framework. And I would like to have Damien introduce himself.
Yes, Damien Short. I'm a professor of human rights and environmental justice at the University of London. I've worked a lot on Indigenous peoples and their relationship to the concept of genocide and settler colonialism in particular.
Thank you, Damien. Martin.
Hi, yes, so I'm senior lecturer at the University of West of England, and my PhD and subsequent research focuses on what I call the political economy of ecologically induced genocide, looking at Australia and Kenya. Thanks.
Thank you. Roz.
Hi, everyone. Ross Segal. I'm an associate professor of Holocaust and Genocide Studies at Stockton University.
Thank you, Roz. Maha.
Hi, good evening, everybody. This is Maha, and I'm a PhD researcher at the Faculty of Law, the University of Antwerp, and my research is looking into Zionism, settler colonialism, and genocide in relation to the Palestinian people.
Thank you. And Shannon.
Hi, my name is Shannon Fyfe. I am an assistant professor of philosophy at George Mason University, and I also teach international criminal law in our law school. My work is at the intersection of philosophy and international criminal law.
Great. Thank you all for being here with us. We'll get started with our first question. What historically has been the relationship between genocide as an international legal framework with requirements for prevention and the prevention of genocide in practice? How does the current moment relate to these cycles of identification and non-intervention? Maha, if we could start with you, please.
Thank you, Arnesa. And maybe I could start by introducing the duty to prevent, both in theory and practice, in accordance with the customary international law, the Genocide Convention, and the ICJ's relevant precedent, but also others, where states' duty to prevent genocide, but also suppress and punish it, but with a focus on the duty to prevent, has been very well articulated and set forth. And just a few reminders about the duty, that it's part and parcel of states' duties and obligations under the Genocide Convention, including not to commit genocide, to punish and ensure effective penalties for perpetrators of genocide, among others. So it's not a standalone duty. And the duty to prevent genocide is extraterritorial in scope, which means that it applies even beyond the geographic location, let's say, where the crime may be perpetrated. And the duty itself to prevent genocide is also triggered, even when there is no definitive determination of whether genocide is taking place or not. And this was very well held by the ICJ in the Bosnia versus Serbia judgment in 2007. And the same judgment also stated about the state's duty to prevent genocide would be heightened when states do exercise certain leverage and influence in that specific context and in relation to the state or actor perpetrating genocide, for example, with their political or economic links, and so on. And in the words of the Office of the UN Special Advisor on the Prevention of Genocide, who has so far been silent and shamelessly failed to impartially fulfill their mandate in relation to Israel's genocidal acts against Palestinians in the Gaza Strip, they specifically, the office, the mandate states that the international community does have a responsibility to encourage and assist states in fulfilling the duty to prevent, to take collective action, to use appropriate diplomatic, humanitarian, and other means to protect populations from genocide and other mass atrocities. And in practice, looking at the other part of your question, to what extent has the Genocide Convention and the relevant UN bodies and organs, including the UN Security Council and the ICJ, have been able to effectively prevent genocide is a serious question that should force all of us to really reconsider the effectiveness of these instruments and sources of international law, as long as they are going to be dominated by a select number of states at the end of the day. And we cannot disregard the considerable efforts that have been poured into atrocity prevention over the past 2 or 3 decades. But at the same time, unfortunately, we have continued to witness in recent history repeated failure of these organs to prevent international crimes, including genocide such as in Myanmar and Darfur, only for example. So, and maybe as a last reminder as well, that the prohibition of genocide is a jus cogens norm, and for which states would have a duty to bring to an end, not to recognize as lawful and not to render aid or assistance to it. So in addition to the duty to prevent genocide, states must also be aware of potential complicity in genocide through their through provision of means or by enabling and or facilitating the commission of the crime in its various elements as it is in the Genocide Convention.
Great. Thank you very much, Maha. Shannon, what are your thoughts on that same question?
It's a great question, and thank you, Maha, for all of that background. And I share your skepticism about the way that the UN organs have been successful at playing a huge role in preventing genocide in the past. Unfortunately, I went to school because I thought international law would protect people from genocide, and unfortunately, it doesn't necessarily seem to be the case. I think civil society has a huge role to play in preventing genocide and has, I think, probably been much more successful than a lot of these international law instruments. So for the ICJ, for instance, thinking about this in the context of what's happening right now, I think there's something really powerful expressively, and there could be something. There have been, a few states and organizations, universities that have felt some pressure from the ICJ's recent kind of preliminary decision in the case of Palestine, that suggests the expressive force of international law in that sense, right? The ICJ saying there's a plausible case of genocide can play a role in influencing states in particular to fulfill their obligations under the Genocide Convention. But there's just no enforcement mechanism. And the ICJ's decisions are only binding on the two parties that are in front of the ICJ. And so there's no legal force on any other states. As Maha said, states might be worried about criminal liability with respect to genocide, and generally, and in this particular case. And as with other aspects of international law, I don't know that international criminal law has a strong role to play. Again, in the prevention side, I think the accountability questions about genocide are quite different, and something that is the case in the recent situation in Palestine is that there was already a situation open at the International Criminal Court, and so the ability for the chief prosecutor to kind of get on the ground very quickly. The situation is already open. You know, I think the prospects for accountability, who knows who will be held accountable or for what. The idea of holding states or leaders of states responsible through in a complicity model would be a very new, and I think that would have very strong expressive force for the future. But in terms of these legal institutions kind of having teeth, I don't know that they do. And I think especially with respect to prevention, the International Criminal Court can't do a lot, at least at this point in its tenure. But I do think that they can play a really strong role in expressing and in condemning, and in hopefully encouraging states to kind of take a different stance, whether that's because of the threat of criminal liability or other kinds of shaming practices. I think that it's a much less direct role that international law has to play than we might hope.
Great, thank you very much, Shannon. You both touched on this. Obviously, looking at genocide historically, there's been very few cases, in fact, not really a single specific case of preventing genocide fully, right? There's been times where genocides have stopped, such as in the case of the Holocaust, or even in the case of the Bosnian genocide. It happened, then there was an intervention. Maha, I'd love to get your, I guess your sentiments regarding the failure of prevention, particularly as it relates to Palestine right now in this current moment.
Thank you. Unfortunately, as you said, in most instances of genocide, they had to happen, and then some form of action was taken after, although in many of the cases it was never sufficient, even after, and the recognition was very timid and so on. But without going into all of these details, when we're looking at the current moment in Palestine, we are witnessing this failure to prevent and to suppress even genocide yet once again. And not only that, but also open and direct and indirect support, whether politically, financially, materially, to the perpetrator of genocide. And this is all happening as literally as the world is witnessing it being live streamed for nearly 5 months now. And as we have all acknowledged by now, and as most international agencies and institutions have been warning against, that there is irreparable harm and devastating consequences to the Palestinian people at large, but particularly Palestinians in the Gaza Strip, who are subject to these genocidal acts by Israel. And the vast majority of third states have failed to take the necessary measures in line with their duty to prevent that we mentioned earlier, despite the very clear warnings of the risk of genocide by various bodies and representatives, of course, most notably that of the ICJ and its provisional measures order from 2 weeks ago. But also, even prior to that, there has been repeated warnings signaled by UN special procedures, by the UN Committee on the Elimination of Racial Discrimination, by academics and experts in the field, civil society, and human rights organizations. And today, about 2 weeks after the ICJ ordered the provisional measures, stating that Israel is possibly perpetrating the crime of genocide, and most countries have, especially those with direct relationships and links to Israel, have failed to take any decisive action or measures to meet their duty to prevent genocide. We're still waiting on states to carry out the necessary measures to meet these duties, whether it's targeted actions, targeted sanctions against Israel and associated persons and or entities, whether it is suspending or discontinuing military assistance and cooperation agreements, imposing military embargoes, stopping the transfer of weapons, arms, and so on, suspending and cutting diplomatic ties. In the vast majority, but not all, of states, none of these actions have been taken. But there have been exceptions, of course, to that. And we've seen some states take more action on the accountability front, which is also part of their obligations under the Genocide Convention. Most notably, of course, the case brought by South Africa before the ICJ. But prior to that, in November, we've seen a number of states make state referrals to the ICC, calling on the prosecutor to investigate, in addition to war crimes and crimes against humanity, also genocide as part of the ongoing investigation. A few days ago, we've seen Nicaragua's note verbal to the UK, Canada, the Netherlands, and Germany for complicity in genocide through the supply of weapons following the ICJ's provisional measures. At regional and local government levels, we've also seen some considerable measures being taken. 2 days or a few days ago, the Walloon Regional Government of Belgium made a decision to suspend the export licenses of ammunition to Israel in light of the ICJ's provisional measures. Prior to the court's order, in November as well, we've seen the Barcelona City Council suspend institutional relations with Israel, citing genocide. Similar action was taken in Liège and in Oslo. We've seen private actors as well, companies like Itochu Corp, the Japanese company, yesterday announcing that it will end cooperation with the Israeli defense company Elbit Systems, again following the ICJ's order to prevent acts of genocide. So while we see the vast majority of states not taking the necessary action, especially those in the Western part of the world, there has been some positive indications coming that also reassure that there is, some sort of interest in preserving the legal world order to a certain extent.
Yeah, thank you so much, Maha. Shannon, I wanted to ask you, considering obviously what we've just discussed, what Maha has said, I'm going to bring Bosnia up again because that really was the last time that the United States intervened in the case of genocide, and they cite it as a humanitarian, intervention. What are your thoughts on what role the United States has to play when it comes to, one, upholding the international legal framework, liberal framework, and also what role and responsibility has to play just general as a sort of World Cup?
They're really good, really hard question because the U.S. has a huge role to play, of course. Just institutionally, they are on the Security Council, and so they are in a position to do a lot just in virtue of the kind of legal structures that we have. But obviously, beyond that, they just have an economic and political hold over so much that happens in the world. And I think what's scary about this is looking at about this particular situation is what it would take for the U.S. to kind of change their policy to what it needs to be for them to play that hugely important role. They're so far away from that, right? It's not just we don't want to get involved in Rwanda because of Somalia, or we don't want to get involved in this situation. This is an active support of the Israeli government. And so I think the fact that they are continuing to do that with momentary, I don't want to say lapses, but moments of saying, oh, maybe Bibi should chill with what what he's up to. Have been and continue to be so supportive of the Israeli government. It's really hard to imagine kind of what it would take, whether that's kind of internal litigation, or clearly the ICJ ruling did not really change. I was kind of hopeful that maybe US policymakers would at least have some kind of, well, we're going to stop telling people they're being ridiculous when they're calling what's happening in Gaza genocide. And I haven't really seen that shift yet. And I'm not sure what it will take for that to happen, because it does seem like such a crucial piece of what the global order needs in this situation in particular, just because of the relationship between the US government and the Israeli government. It just would take a whole lot to make that shift. And I unfortunately don't see it coming yet.
Absolutely. Thank you so much. I'm going to hand it over to Ben.
Yeah, and I sort of related to what Shannon and Maha both got at in relation to sort of the monopoly on power and influence over international law. It's clear that international law has its grounds in imperialistic and colonial origins. It often prioritizes the interests of nation states, and particularly powerful nation states, over the needs of peoples, in particular also stateless peoples and refugee communities. And so how does this reality interact specifically with genocides in the settler colonial context? And I'll pass it to Damien.
Thanks, Ben. Well, I thought I'll start off with a little bit of a discussion about how this as how I've approached it in my own work, largely in the Australian context. But to begin then, as post-colonial critiques of international law often pointed out, as you just said, Ben, whilst it has evolved over time, it was largely shaped by the European colonial powers. The principles and norms themselves are often established and reflective of the interests and values of those colonial powers, leading to a system that has often been perceived as biased or favouring the colonizers. But for me, I think the state-centric focus of international law was arguably a sort of product of that, and I think that's hindered a lot of what I've looked at in Australia in particular. International law traditionally places a strong emphasis on the sovereignty of states, right? Which, of course, causes problems for those who don't have their sovereignty recognised. But when you combine that then with the realities of settler colonialism, dispossession, dispersal, subjugation of indigenous peoples, it inevitably results in a lack of respect or so-called recognition of their rights. Most importantly, and somewhat ironically, self-determination under the UN Charter, for example. Now, in my early work on genocide in the settler colonial Australian context, I was struck by how the international legal understanding and often popular understandings focus significantly on perpetrator intent rather than the lived experiences of the victims. Now, as a human rights scholar coming to this context, I found that really quite perverse, as we place the experiences of victims of human rights abuses sort of front and center of both our scholarly advocacy and our lobbying in particular. And I remember there was a famous quote by Professor Kenneth Minogue, who argued that, if I quote this correctly, indigenous peoples, he said, in their more extreme moments have a tendency to dramatize their suffering by invoking the term genocide. And that sort of quotation had real profound effect on me. I found it extremely disrespectful and was subsequently keen to examine the historical development of the term, including how it found its way into international law, for example. And in going back through Lemkin's work and looking at the work of Dirk Moses and John Docker, who had done this sort of early work before I did, I was really struck by how the understandings they unearthed with going back through Lemkin's and what was unpublished work at the time, I found that far more consistent with the lived experience of the colonized than I did the sort of popular understandings that focus very much on perpetrator intention, etc. And that was really, really important, I think, because it really did, in many ways, sort of draw attention to the fact that the indigenous experience of settler colonialism and their experiences and apt way of describing their suffering as genocidal was much more in keeping with a broad sociological master concept that Lemkin had gone through, a lot of, was a pain, should we say, then, to fully describe, right? So I was really, really struck by that. And I think it was Larissa Beran, the Australian Indigenous scholar, who said that, genocide accurately describes our experiences as colonized peoples. And I think that drew attention to the notion that colonialism is often inherently genocidal, whether or not it's recognized as such in international law. And again, that was something that really came through strongly in Lemkin's work. And it's something that I found very, very important in trying to understand exactly what is at stake for the colonized. And more often than not, exactly what is at stake is their very survival as peoples. So yeah, that's basically my long-winded answer to the question. I think Martin's next.
Yeah, thank you, and hand it over to Martin.
Yeah, I would agree with everything Damien said there, and just add that it's interesting when you look at the sort of the social construction of the Genocide Convention, the preparatory papers. You see how the convention was structured in such a way that the signatories, those states who ratified the convention, were not incriminated. They didn't incriminate themselves. So various so essentially the original, I believe, Raphael Lemkin's original sort of definition of genocide, which was much more expansive. Culture was the master concept. In the original draft of the convention, was lost in subsequent drafts. Signatories like the Soviet Union and obviously the United States and Britain at the time, which was still a big colonial power, were keen to avoid incriminating themselves. So they kind of bowdlerized, if you like, and sort of denuded the definition and shrunk it so that it sort of raised the bar and made it very difficult to prosecute themselves. Because they were still, of course, controlling, dominating, marginalizing, and sort of slowly eradicating their own subject populations. And it enabled it sort of preserved the right of states to continue waging, sort of annihilatory wars without fear of any comeback, essentially. So I think one scholar, Dominic Scharler, said that he said something like it was the constellation of Cold War politics that ensured that the convention, or rather the definition that would be seeded in the convention, would be continually shrunk to ensure that the major powers would never face any comeback, any consequences. But I think it is also a little bit ironic in another respect, because when you look at the work of Raphael Lemkin, if you look at his book, his unpublished magnum opus, The History of Genocide, even if you look at the book where he originally coined the term genocide, Axis Rule in Occupied Europe, he consciously situated his work within a kind of intellectual tradition going back centuries that were critical of imperialism and colonialism. And of course, in his original definition, he stressed that genocide was necessarily a colonial sort of enterprise. So, yes, international law is a product of colonialism and the European colonial powers, and yet the Genocide Convention indirectly is also a product of Lemkin and others' sort of anti-colonial and anti-imperialist critiques. So it's an interesting paradox, almost a kind of dialectical relationship between these two competing intellectual traditions.
Thank you, Martin. And Roz, I'll pass it to you and then have already a follow-up question.
Yeah, so it's two things that I want to emphasize here I think are important in terms of considering the origins of genocide in international law. One is obviously the context of the Holocaust. I mean, no one used that word, of course, immediately after World War II. But the idea that it's kind of the implicit idea, I think it wasn't really expressed in this way also, but that the Nazi assault on Jews was exceptional and it needed to be separated, particularly from genocides in a colonial world, right? And I think that that's part of the reason that we have the construction of genocide as a crime basically as the international legal system reemerges after World War II with genocide as its, a key innovation. It's very difficult to prove genocide precisely because it needs to be separated in this way from the genocides in the colonial world. But the more important really, or the related implication of that is that Israel, which was the country that was seen to emerge from the Holocaust, and where also a lot of Holocaust survivors chose to try to build their lives, right, was also then, by implication, seen as exceptional, right, or unique in the international legal system, so that actually impunity for Israel was really baked into the international legal system from the beginning. Now, this is very important also to understand that the international legal system emerges with the denial of the Nakba, right? Because of this Israeli impunity for Israel, but it's also related to the urgent need to deny the character of the Israeli state as a settler colonial project, right? Which, of course, we can only look to Zionist historians and to key figures in the Zionist movement itself, like Zev Jabotinsky, for example, to learn about the settler character of Zionism, because for Jabotinsky, for example, right, the founding figure of revisionist right-wing Zionism, in his key text, The Iron Wall from 1923, he talks about the settler colonial dimension of Zionism explicitly, right? That's why we need an iron wall, as the title of the essay. So that's one context I think that's very important, and in that sense, the ICJ ruling is a real watershed breakthrough moment because it is the end of Israeli impunity in the international legal system, right? Now, it could be a massive breakthrough moment. It could be a much less massive breakthrough moment. I agree, Shannon, that it could, but I think, and in part, it also depends on what we and, people around the world do with it, right? Because I think we got to the ICJ to begin with because of massive protests around the world, right? Otherwise, I don't think that South Africa would have brought the case that easily to the ICJ. But I think that the end of Israeli impunity is, in this kind of context of how the concept of genocide emerges that I briefly described, is one important way to look at it. Very briefly, just another piece to this. I mean, because the judges, the provisional ruling of the ICJ actually, of course, quoted a couple of examples of this explicit, direct, and unashamed statements of intent to destroy in the language of the convention, right? And that's so very important because of the place of intent in the crime of genocide, and which brought us to this watershed moment. And then the question really is why do we have, why are Israelis expressing themselves in ways that perpetrators usually don't? And the reason goes also back, of course, to settler colonialism, because Israelis are imagining that they are fighting a colonial war against savages, okay? Now, this is actually very important because, if I'm not mistaken, the origins of the international legal system are that this is something that applies to regulate wars between, quote, civilized nations, right? It's never supposed to apply to the colonial world, hence colonial genocides, right? Now, because Israelis really imagine that they're fighting a colonial war against savages, then there's no problem, like General von Trotha in German Southwest Africa, right, to be explicit, to issue extermination orders in that case in German Southwest Africa, or everything that we've seen, right, and quoted again and again and again, right, filled with dehumanizing language since 7th of October, right, which then brings us, right, to the ICJ ruling again, which highlights even more now, when we think about the origins of the international legal system, how the ICJ ruling is actually an accident of the system, right? The system was never supposed to, sit in discussion of Israeli genocide, right? That's why we have decades of impunity to Israel, right? Even though a mountain of evidence of the violations of international law. So I think these two things are very, very important. They show how we're in this unprecedented moment that could have implications, of course, also for Palestinians themselves. And, there is also something to be said about, of course, Palestinians, the effect that this could have on, de-escalating, it doesn't look like right now, but de-escalating Israeli violence on Gaza specifically, but also there's the occupied West Bank and East Jerusalem, and actually Israeli Palestinians themselves. But also this could have implications, I think, well beyond the case of Israel-Palestine. So.
Thank you, Roz. And my question, I guess, is sort of broadly for all three of you, and each have alluded to sort of this erasure that functions in settler colonial contexts, both of like physically the presence of the indigenous community, but also of their experience, also their capacity to articulate this experience. And so can you talk a bit about the relationship between like the genocide denial we're seeing now and the relationship of the erasure and the denial sort of implicit in settler colonialism, how those two might engage in conversation with each other? And I guess I can give it to Damien first and we can just go in that order.
Sorry, you just completely dropped out there for a second. I lost my
good. Asking about the relationship between genocide denial and erasure that's sort of fundamental to settler colonialism.
Yes, it's a very, very important question. It's certainly something I've seen a lot of in my work. In fact, the sort of like the hegemonic projects of sort of state legitimization, where the state itself hasn't been legitimately configured, lends itself to a sort of denialism, based because the founding nature of the illegitimate state itself relies on a sort of, as you said, an erasure of the indigenous experience. So yeah, they from the work that I did, especially in the Australian context, is part and parcel of it. And I think it's something you see across a whole range of other contexts, arguably Palestine as well, where the construction of the state itself lends itself to or requires, then should we say, that kind of denialism that you're talking about. Absolutely, yeah.
Martin or Roz, Martin?
No, again, just to echo everything Damien said there. I mean, the work I did on Australia as well and Kenya more recently is predicated on this sort of. Well, in the case of Kenya, it's interesting as well because the genocidal process, and I think it's important to understand genocide as a process, as a structure, not just as kind of events that you can drop a pin on a historical timeline, has unraveled and always mutates into different forms where on some occasions and some junctures, one technique predominates over another. It could be cultural erasure, economic destruction, or even indeed physical destruction in certain periods, as we're seeing today, obviously in Palestine. In the case of Kenya, of course, it was a British colony. It was, sort of established in the late 19th century. And it went through a number of phases. You're focusing on land annexation, supplanting of indigenous peoples with British settler colonizers, involved cultural erasure as well, of course. And then towards the end, in the final phase of the colonial period, when we see the imposition of martial law, and the beginning of what's known as the Mau Mau Rebellion against the British colonial authorities and the British military, we see a kind of intensification or concentration, if you like, of a phase of the continuing genocide, which was in the early 1950s. It began 1953, I believe, and that was only 8 years after the death camps were liberated in Europe, and yet we find the British Army is involved in systematic ethnic cleansing, villagization of entire indigenous peoples, the erection of a whole elaborate apparatus of torture, and the most barbaric methods used to violence inflicted on these subject populations. And I think to this day, even though there was an important court ruling in the High Court in Britain a number of years ago, the vast majority of the British public are either completely oblivious to the genocide that the British colonial authorities were responsible for, or in a state of abject denial about it. So I think in some respects this is just part and parcel of every settler colonial project. And indeed, the work I've recently published with Damien focuses on the genocide that's continuing today in Kenya. And this time it's the Kenyan state, the post-colonial Kenyan state, which has inherited the biopolitics in many respects and the economy of the British, is continuing to subject those it considers not civilized enough to genocidal relations. And of course, they are in complete denial as well. So to recognize a relationship as genocidal is to concede that the entire state is not legitimate. So it's necessary, isn't it? I believe to practice denial.
Yeah, I'll just add, I think that, the denial of the existence of Palestinians as a people is an integral, and the belonging of Palestinians to the place, of course, is an integral part of the Zionist project, certainly, in the way that it manifested itself in the States in 1948 and afterwards, right? And in that sense, we see, I think, something very significant in the ICJ ruling, because the ICJ ruling actually, because of the nature of the Genocide Convention, has to recognize, right, Palestinians as a national group that is protected, right, under international law. Now, of course, no one needs to wait for the international legal system for that recognition. But in the context in which we're having this discussion, right, this is, I think, incredibly important, again, when we think about this watershed moment, right? I mean, the idea that Israeli politicians like Bezalel Smotrich just recently, before the 7th of October, can stand in Paris and say there are no Palestinian people, which of course is a common practice of Israeli politicians and others for decades, right? That is no longer possible, right, moving forward.
And before we move on, I want to give Maha the opportunity to quickly jump in, and then I will pass it off to Arnesa for our next question. Oh, Martin's going to jump in as well. So, Maha.
Thanks, Ben. I just wanted to briefly mention that the denial is also not exclusive to the crime of genocide in relation to the current context, but the denial has been built up, let's say, over the years because of the pervasive impunity that has been afforded to Israel. So the denial is also in relation to apartheid, in relation to persecution, in relation to annexation, in relation to the illegal military occupation, in relation to the whole set of tools and systems that the settler colonial project has been imposing for decades. And as Martin has said, genocide is a process, and there are multiple or several phases throughout. And this denial, this persistent denial and failure or inability or deliberate inability and sorry, the word escapes me now, but the failure to recognize that and all of these is what has led to where we are today in this phase of the genocidal process.
Martin?
It was actually just a question, really, to Maha, Raz, and anyone else who would like to jump in, which is, there is, of course, denial, but at the same time, what I've seen is prominent members of the political elites, members of the Knesset, talking heads in Israeli media, and even in some cases, intellectuals and historians like Benny Morris, who are actually quite open about how about the genocidal nature of not just, of course, this current phase in a genocidal process and the war, but also opened about Israel being fundamentally a genocidal project. So Benny Morris talks about that, saying, in fact, the ethnic cleansing perhaps didn't go far enough, that it should have gone further, and that in some instances, using modernizing discourse, as long as the end goal is a progressive one, it's justified. If the casualties that are along the way, they're justified. So trying to understand this kind of, on the one hand, of course, there's plenty of denialism. On the other hand, there are some recently in Israeli society that are openly celebrating the fact that they're committing genocide. So I'm trying to reconcile those two things.
Yeah. If you don't mind, I'm just gonna jump in real quick, Martin, because you make a really excellent point. And I think in my own, I suppose, research and comparisons of other genocides, I found that this situation is particularly closely aligned to the case of the Bosnian genocide, with some notable differences, particularly because this is a colonial case. There's, Israel is a settler colonial power, and they have been under occupation for 75 years. When it comes to specifically how, I suppose, the political leaders are talking about it, celebrities, it's not just about, genocide denialism, right? It's almost like this general admittance. It's not just incitement. It goes a little bit beyond that. And that we can still, unfortunately, see even 30 years after the Bosnian genocide, very much alive in both the Republika Srpska entity of Bosnia and the Serbian public. It's a sort of, catch-22 that genociders like to use, where it didn't happen, but if they did, they deserved it. We needed to do it, because if we didn't, then they would have killed us. And the biggest similarity, I suppose, that I found when it comes to the current genocide in Gaza and the Bosnian genocide has been the mentality of the genociders and their supporters, right? They have convinced themselves and convinced their people, in this case Israelis, that the other side are terrorists, and there is a very real danger that if they do not commit this genocide, this ethnic cleansing campaign, they will be wiped out. We know it's propaganda. It was propaganda in the case of, Serbia in the 90s. It's propaganda now. But it is interesting that, unfortunately, in the case of the Bosnian genocide, that sort of genocide denialism has not subsided. It is very much alive. In fact, it is only getting worse. And I'm afraid that, with the case of Israel, I have never seen such open intention of genocide being so openly and loudly and proudly declared, not even in the case of the Bosnian genocide. I think that has shocked most genocide experts, scholars, academics, legal experts, because we've never seen that before. So given that, I think it'll be really, really interesting for us to see what's going to happen 30 years from now, and how will Israeli society go through a period of reform and actual progress, or is it going to be similar as with Republika Srpska and the Serbian state? Raz, Maha, did either one of you have anything to add? All right, thank you both. Our speakers have mentioned Lemkin a lot. Now, while Lemkin was the person to officially define genocide, we know that genocide has actually existed in practice long before it became a formal crime under international law, with requirements like intent, especially. How does the legal concept of genocide modify its sociological nature? And does the legal structure of genocide prevent reconciling with its structural or temporal dimensions? How does this specifically unfold in the context of Palestine? And Damien, if I can start with you.
Yes, thanks, Arnesa. It's a very interesting question. Well, as Martin pointed out earlier, in addition to Lemkin's tireless, work and lobbying, the legal definition of genocide was, I think what political scientists would call as the product of the balance of power between political interests, right? And as such, it imposes a much narrower interpretation than Lemkin envisaged, primarily removing the cultural method, which, if I'm quoting Lemkin correctly, involves attacks on what he called the shrines of the soul of a nation, which I think is a lovely way of putting it, which is partly why it was resisted, as we've heard, by states with a colonial past during the construction of the Genocide Convention. But also international law, as we've heard, involves a very, very specific form of intent. And in many settler colonial contexts, intent has often been more readily ascribed towards expansionist land grabs, appropriation of lands, and resources. But as Deborah Bird Rose put it, and again, I love this quote, she said, all the native has to do to get in the way of settler colonialism is to stay at home. So you get that exterminatory logic that comes along with it, much broader understanding. But, in popular consciousness, genocides are often seen to occur in neat, compacted timeframes. So this goes to the sort of temporal dimension again, which doesn't easily cover what Tony Barter has called, long-term relations of genocide, or ongoing long-term genocidal behaviors, which I think, accurately can cover Palestine at least from 1948 onwards. So in terms of the sort of temporal dimension, the legal understanding of genocide, I think, has difficulty dealing with anything more than, I think, what Dirk Moses called genocidal moments, right? Rather than long-term structural genocides that are themselves a product of, a long-term settler colonial relationship involving land and resource appropriation, occupation, and extreme control of native populations. So I think that's the trouble. When you compare the international, well, it's one of many issues, should we say, but when you compare the international legal framework with the sort of the sociology of genocide and the research that we've seen in the post-colonial genocide school, we're much more interested in highlighting the lived experience of populations living under long-term settler colonial relationships. And I think Tony Barter's his huge contribution, I think, he sort of crystallized around that notion of relations of genocide. I think it's a really interesting way of putting it. And I think it captures that temporal dimension, which, somewhat escapes the popular understanding and certainly the legal understanding. That's sort of, my 2 cents worth.
Great, thanks, Damien. Roz, over to you.
Yeah, well, I think that, in the case of Israel's assault on Palestinian society and culture for decades. Obviously, the term of genocide, again, the whole international legal system, which affords Israeli impunity, also blurs all of these forms of mass violence, right? Beginning from the Nakba itself, and of course, what Palestinians, of course, insist rightly so as an ongoing Nakba, right? Until today, it involves military occupation and siege and mass incarceration and forced displacement and actually destruction of the environment in various ways, and all these things. But so again, I want to focus here on the watershed moment, and particularly because we've heard, as you said, Martin, calls from the 7th of October for a second Nakba, right? I think that there's indications, a lot of Palestinians now talk about the way in which this is really a moment where they're now understanding in ways that they haven't before the stories that they've heard from their grandparents, for example, or family members about the Nakba, in terms of what the Nakba actually was, right? Now, in this sense, we can think about a related case to the ICJ, the well-known case in California that the Center for Constitutional Rights brought against Biden, Blinken, and Austin for U.S. complicity with Israeli genocide and the failure to prevent genocide. And the really unprecedented hearing in that case in the end of January, where for 3 hours the judge allowed for Palestinians to testify in court. Palestinians, including a Palestinian doctor from Gaza who testified, and Palestinians whose families are in Gaza, who lost dozens of family members in this current attack. And they all talked about, and they started their stories and emphasized the Nakba, right? And we've heard in that federal court in California that day the word Nakba, I think, more than we've heard it in U.S. institutes, right, ever taken together, right? Now, this is very important because these cases are actually related in various ways, I think, the ICJ and the CCR case in California. And I think that if the ICJ marks the end of Israeli impunity, right, then we also see here the end of Nakba denial, right? And that also means that we have a moment to really actually rethink the whole long-term process of Israeli assault, destructive assault on Palestinians and Palestinian society. Also because I think that, and that's, something that is worth much more discussion, but we talk about global Holocaust memory, right? And there's a lot to say, of course, about the weaponization of the Holocaust in this context. But we're now, because of the implications of the struggle now against Israeli genocide in Gaza, and the global South sees this, rightly so, as a pivotal moment, right, in a kind of revolution, actually, against an international system, an international legal system, right, that has not worked for people in the global South very intentionally. And because this revolution now, in a way, we could say starts in Gaza, right, then we can also say, in a way, that we're entering an era, perhaps, of global Nakba memory, right? Which really offers a different way of looking at all of these things, of genocide, of international law, of Israeli history, of Palestinian history, right? So again, I want to emphasize the watershed moment here as at least as a significant potential, and we're already seeing some. I mean, this is the end of Nakba denial, right? So I think it's very, very significant.
Thank you very much. Martin.
I think I agree with everything Raz said there, and I think it is definitely a watershed moment. I think it's sort of laid bare, or maybe pulled back the curtain a little bit. It regards not just the settler, colonial, and genocidal nature of Israel, but also the nature of neo-imperialism. And it's important, I think, to understand the critical role that the United States plays in all this as well, not just in terms of the, complicity and the direct commission of genocide as well, because, of course, they pulled funding from UNRWA, which, of course, basically ensure that millions of Palestinians who rely on UNRWA for essential food, medicine, and so on, would be denied that aid in conditions where they are facing mass starvation, plague conditions, and so on. So now the United States and the United Kingdom and Canada and other countries who've pulled funding from UNRWA are now responsible not just for complicity, but now direct commission of genocide. I think it's important to understand that, this case will hopefully have consequences in the UN General Assembly with states, exercising their universal jurisdiction to prosecute those responsible for genocide if the ICC is not willing, which probably it won't be. That's another debate, but there's interesting differences, isn't there, between the ICJ, which is an institution of the UN system in which every member state is a part, whereas the ICC seems to be more at the whim of the UN Security Council and seems to be more politicized. So hopefully, member states of the UN will exercise their universal jurisdiction, perhaps even, issue sanctions against Israel, deny consular, end consular relations with Israel, deny travel documents and so on. But of course, hopefully it will create a political space for an re-energized BDS movement and pro-Palestinian movement, which can put pressure on from below key powerful states, in particular the United States, because I think it's the US unconditional support for Israel, because of the role that its elites within the Pentagon, within the State Department, consider Israel playing as a kind of watchdog state in the Middle East, in a key area, a geostrategic area, in order to ensure that there is no pan-Arab unity, and there is no one state that predominates over this vital region to US interests, something that senior state planners recognized even during World War II, let alone in the post-war settlement. So how do we end this kind of unconditional support that the US provides for Israel? Well, either it's going to come from massive pressure from below because of a revitalized, re-energized pro-Palestinian movement, and or resetting of the global economy, where the United States is no longer the economic hegemon, or it could be perhaps the drying up of vital fossil fuels in the Middle East, so the region no longer becomes a key to US power as a global hegemon. Who knows? But perhaps a combination of all those three conditions would finally end Israel's impunity. So I think that's important to consider. But just to briefly come back to the question, in terms of how does the convention and the legal structure, modify the sociological nature of genocide. Of course, this sort of fixation on intent, genocide mens rea, makes it virtually impossible to recognize, let alone prosecute and prevent structural genocide, particularly in a settler colonial context. It's not just for lack of space that it's not possible to put modes of production, political institutions, and colonial rivalries on the dock, right? So of course, the legal nature has essentially rendered invisible settler colonial genocides, and that's the whole point, isn't it?
Yeah, great. Thank you so much, Martin. On this sort of topic, and I believe everybody has mentioned and reiterated that there is complicity in this genocide. There are several states, most notably probably the United States, that are technically complicit in genocide. Is there a possibility for us, the people, organizers, lawyers, activists, whoever, to sue a state in a national court for complicity in genocide using the ICJ initial provisions as the basis? So maybe it doesn't have to be the most guilty country, but it could possibly be a country where such a case would be more likely to win. And I would actually like to get Maha's expertise on that. Would this be, and this is a question that's come up over and over again, and people really want to know, would it be possible? Could I sue, let's say, my native country of Bosnia for not doing enough to prevent genocide in Palestine, and also being a citizen of the United States? Could I sue the United States for being complicit in genocide and going against the provisional measures imposed by the ICJ?
As Roz already mentioned, even prior to the issuance of the provisional measures by the court, there was already the case brought against the US president and the other representatives of government for complicity in genocide at the US federal court level. There were also other actions, legal actions taken across Europe in particular. Most have not been specifically in relation to genocide, except for one, which was in the Dutch court system with regards to weapons and materials related to weapons manufacturing transfer by the Dutch government to Israel. And that case was premised on the Genocide Convention and the failure to meet the duty to prevent and potential complicity in genocide. So even prior to that, there was action carried out by civil society organizations and so on. But I think now with the court's order and the provisional measures, they give even an added, let's say, a substance to the arguments that could be made before national courts in relation to the duty to prevent and to not be complicit in genocide. So definitely, in fact, in the view of many, especially those who were skeptical about the provisional measures really meeting the urgency of the situation, because it did not call for an explicit cessation of military operations in and around the Gaza Strip, as was requested by South Africa. For many people who were thinking like that and were skeptical a little bit, the most important component of the provisional measures is what it would mean for third states, for those who are complicit and or enabling and or facilitating the commission of the crime. So it definitely adds more to the already existing obligations and duties that are very clear. But again, it beefs up the standing point.
Right. Thank you so much. Roz.
I just wanted to add that, just an example, a few days ago, I don't remember exactly when, there was the letter by 800 serving officials of the UK and US government. And people who basically said that they're very concerned and specifically citing the ICJ ruling and specifically talking about complicity, right? So that they're very concerned now that this is very different than anything that they had seen before, because now we're talking about plausible genocide and therefore possible complicity with genocide. And this is serving officials. I think this also speaks to, I'm not an international lawyer or a lawyer at all, of course, but I think that it also speaks to what Shannon said before about the expressive force of law, and law always intersects with politics, right? So I think that there's both the formal possibilities that you just described, Maha, but there's also, even larger impact here of how people understand this, right? And the potentials of what we're seeing now moving forward in this struggle.
And I guess just to chime in on the U.S. case specifically, I mean, the district court in California dismissed the CCR claim based on this sort of loose doctrine that the court's not going to interfere in U.S. foreign affairs. But importantly, the judge very much leaned on the ICJ decision, and at the end of the draft order, the order that he put out, wrote that this is a case where the preferred outcome is inaccessible to the court. And cited the ICJ decision and saying that it is plausible and confirming that it is plausible Israel's conduct amounts to genocide. And the court, though it didn't make a legally binding order in dismissing the case because it couldn't, still the judge wrote that he implored the defendants, the President of the United States, President Biden, to examine the results of their support for the military siege against the Palestinians in Gaza. And that was the specific language used by a U.S. federal judge. And so you see sort of this major shift coming out of the ICJ decision, which I think pulls us nicely into sort of our final reflection question, which is that we had this ICJ decision, but since then, you've had Israel continue their campaign in Gaza. More than 1,000 have been killed since. Now the death toll sits at around 27,000 or more. And so with this decision, but the continuing violence, how do you think the path forward will continue? Do you think, obviously, political measures at the Security Council to enforce the ICJ decision are unlikely given the U.S. veto power? But I guess this is sort of one of those where do we go from here questions, and I know you all have alluded to that a bit. And so I guess I'll start with Damien and then go down the line before we wrap up.
Well, I'll leave the sort of legal dimensions to the lawyers, but I think, as Raz was saying, I think the ICJ is a watershed moment. And I think at the minimal level, for me, I think Raz also alluded to this, I think it will help people understand the situation better and allow scholars and activists to unashamedly use the genocide concept to describe, the lived experience and the terrible situation in Gaza at the moment and Palestine more generally. And as Martin also pointed out, embolden and revitalize, re-energize pro-Palestinian rights movements. So I see there's a serious, discourse level, improvement in the position now since the ICJ ruling. So I think for me, on a minimal level, I think it will allow a better understanding of the situation and allow that sort of the use of the genocide term to become more popularly, utilized in this context. And up till now, it's been a much more difficult task. So I think that's a very, very important shift, and one that we have to be very happy about. Where we go from here in terms of the practicalities, what happens with the legal side of things, I wouldn't like to say, but I'm more optimistic now than I was prior to the ICJ ruling. So I'll hand over to the others for legal commentary.
Thank you, Damien, and I'll hand it to Maha to provide sort of your final reflections.
Thank you. I fully agree with what Damien said. Despite the beyond tragic and catastrophic situation on the ground, we could phrase it as a win or a victory or a positive move or development, but with what the court has said and delivered in its provisional measures already, and the fact that Israel is on trial for genocide, that in itself speaks a lot and is a long overdue development, I would say, because as a settler colonial state and project, and throughout the different tools and episodes over the past 75 years plus, clearly the intent is to remove, erase, and eliminate the Palestinian people from the land. So that should have been investigated, the crime of genocide, well before this genocidal aggression. But at the same time, unfortunately, with the provisional measures, once again, we are met with the limitations of international law, with its mechanisms, with its sources, between theory and practice, and between practice and reality, between the courtroom and the reality of the people on the ground. And this goes again to the first question that Arnesa asked us about the prevention and the effectiveness of it and whatnot. And the fact that thousands and maybe hundreds of thousands of Palestinians, especially in the Gaza Strip, were disappointed by the fact that the court did not explicitly call for a cessation of the military operations. I think that speaks a lot of the discrepancy between the victim that is subjected to the oppression, to the genocidal violence, and to the theory and to the books and the courtrooms that we are all dealing with. And it also reflects not only months worth of frustration and disappointment and a loss of faith and hope in the international legal system, but decades and decades of that for Palestinians. It's not the first time that the rights of the Palestinian people and justice has not been afforded to them by the international mechanisms as such. And unfortunately, it has proven ineffective. But at the same time, we are seeing developments as well in how the crime of genocide is being utilized. It's no longer exclusive to one group or another, one geographic location or another. That's very important. We're seeing the law being taken forward in the right direction, thanks to a lot of efforts from the Global South in particular. But at the same time, the most important issue at this very moment is that there is not enough time to be entertaining the development and advancement of the law, of the courtrooms, of practitioners. The move and the action needs to happen today in order to stop the genocide, in order to get to a point where the aggression comes to an end.
Thank you. Martin, any final reflections?
Yeah, no, I think it's just to stress again, this is a watershed moment, and I think lots of people will be skeptical or even cynical about what international law can achieve. Yes, the structure of international law, or even the geopolitical underpinnings of international law, perhaps will militate against ultimately resolving this for the good. But I think the geopolitics can change when the politics on the streets changes, and I think it's too early to say. But I'm cautiously optimistic that we're seeing levels of pro-Palestinian protests and demonstrations on the streets across the world that simply unprecedented. I don't think we've ever seen the scale of protests solidarizing with the Palestinian people before. I mean, this is truly on another level. And I'm always reminded of, I think it was Richard Nixon during the Vietnam War protests, who said, basically said in his memoirs that they were at the gates. I was terrified that they were going to come in and storm us, in the White House. So we have to make our politicians terrified and force them to change. And I think that can happen. We can make them realize it's just no longer in their interest anymore to support and enable a settler colonial project like Israel. And I think we're seeing the beginning of the end of, maybe I'm being overly optimistic, but I think we're genuinely seeing the beginning of the end of the last military occupation and settler colonial projects supported by Western powers. I want to leave it on a positive note.
Thanks, Martin. Roz?
Yeah, just to reiterate, I think that one of the things that could come out of this watershed moment is to continue this move of forefronting Palestinian voices and perspectives and histories and experiences, and especially, we're all academics here on the screen. In the academic world today, we see in Europe, we see in the UK, we see in the US more and more initiatives of officially cutting ties with Israel based on the ICJ ruling. This is not anymore, an academic debate. This is not anymore the question of whether someone is or is not an anti-Semite, as you can see now, is off the table. This is about possible complicity with genocide. And because Israeli universities, as we know for decades, have been very deeply involved in occupation and in siege and in oppression and in dispossession, and so on and so forth, not to mention, of course, the Palestinian Israeli students in Israeli universities who face discrimination and oppression and silencing, right? So I think that forefronting Palestinian voices and perspectives and scholarship and teaching this and now using this moment to really, completely move beyond silencing of all of this in universities in the West, right, is also very significant. And I think we're already, if we're following calls from academics in the Netherlands in the last few days, in the UK and the US, of what's going on at Brown University with the hunger strike of the students, with with other places, this is very unprecedented, and it's on us to push this forward.
Arnesa?
Yeah, absolutely. I just 100% agree with everybody's sentiments. And I really want to touch on what Maha said about the importance of us understanding the differences in our reactions as academics in comparison to the actions of those who are on the ground, who are unfortunately waiting by the phone to hear news of their family or enduring the suffering of the bombing themselves. This decision by the ICJ, these provisional measures were in many ways, everybody has said, watershed moment, but really, I think, impactful and shocking in a way that, yes, I absolutely think we need to understand the disappointment that the Palestinians on the ground feel at the fact that there was no call for ceasefire, there was no cessation of military activity. But at the same time, a few things for people to remember. One, there has never been a country that has been convicted of genocide. The closest we ever came was in the in the case of the Bosnian genocide, Bosnia versus Serbia. Serbia got convicted of failure to prevent genocide, but not genocide itself. Those provisional measures that were enacted in 1993, the Republic of Bosnia and Herzegovina asked for cessation of military activity, so a complete and total ceasefire. That was not implemented. In fact, the provisional measures that were impacted in the Gaza case went a bit further than they did back in 93. And in fact, they went a bit further than they did with the Gambia and Myanmar case as well. And I think they were just about the same. I think that's really, really, really important for us to remember, to keep that hope alive, while still giving the space to Palestinians for us to hear their pain, their very real lived experiences. I'm a big critic of the international legal framework of genocide. I'm a big critic of, for example, the Dayton Peace Accords. But I also know that in my country, there's a saying, as long as there's no shooting, right? We'll accept whatever it takes. Peace is peace. Peace is better than all of us dying, as long as there's no shooting. And as much as we want things to change, we know that change comes overnight. What we should be working on, particularly as academics, as people who live in the West, who have a voice, who have a platform, is try to center the experiences of Palestinians, one, and two, trying to keep that hope alive for everyone, that things are going to get better, that the shooting will stop, the deaths will stop, and some justice will finally prevail.
Thank you, Arnesa, and thank you to all the scholars from the expert group who joined us today, as well as those who tuned into today's conversation. And thank you to Law for Palestine for bringing this conversation together as well. As a reminder, those who tuned in, follow Genocide Experts at Genocide Experts on X, as well as Law for Palestine at Law4 Palestine on X. There you will see updates about the expert group's work, including op-eds and when we will announce our next public discussion. Thank you all.
Thank you, Ben and Arnesa, for moderating.
Thank you, Maha. It was lovely.
Thank you.
Thank you, guys. That was brilliant.
Thanks,
Bye.
Mark.
Cheers. Bye-bye.
Bye.